Welcome students to the week 6 lecture for LW305, Current Developments in Pacific Law. The topic of the lecture today is Post-Colonialism, Social Theory and Law. This slide shows an overview of the lecture for today, not overly complex. We're going to talk about post-colonialism first, and we're going to talk about feminism as a social theory second. So jumping straight into it and without wasting any time, what are we talking about? All of us know about colonization of Pacific countries. All of us have been made to endlessly study colonization and colonialism from different perspectives. For example, you've studied colonialism from historical and anthropological perspectives. You have studied colonialism from a legal perspective. For example, you've identified sources of law and traced the legal authority of different colonial and customary orders. You've studied the post-colonial era or the post-independence era in which we live. Well, today we're talking about post-colonialism as a political theory. Most of you will have thrown the word theory around, but it can still be a scary and confusing word at times. So let's break it down. A definition for theory is an idea used to account for a situation or justify a course of action. An idea used to account for a situation or justify a course of action. We can simplify this and say a theory is an idea that tries to explain something. For example, a case theory that a police investigator or prosecutor comes up with is their idea about what happened based on the evidence that they are relying upon. They were not present to see the crime, so they can only theorize or speculate as to what happened. Of course, if the accused was caught red-handed with a bloody knife in the victim, there is strong evidence supporting the theory or speculation that the accused stabbed the victim. Well, political theory is the study of questions about the nature, scope, and legitimacy of public agents and institutions, and the relationships between them. Different political theories seek to explain different phenomena we can identify and study. Examples of phenomena include ideas such as justice, legitimacy, liberty, law, power, identity, culture, religion, and more. As you can imagine, all of these things are very complex, and they all exist in society in different ways, and they all interact. And there are many different ideas about how these phenomena emerge in different places with different socio-legal, economic, and geographic starting conditions. Well, post-colonial theory tells us that the effects of the colonial tools and colonial rules can help us to understand why things are the way we see them today. And hopefully, at least in some situations or for some issues we discover, that might offer insight into how we can go about solving those problems. Study can also reveal to us the hidden biases within all of us. Are there hidden biases within you which support patriarchal structures within society? Men as providers, women as childbearing servants, or some variation of that. Hidden biases. When will a Tongan woman have a constitutional right to own the land she was born on? The way that colonialism took place throughout the Pacific involved policies that limited Indigenous involvement in commercial and political developments. right from the late 1880s up and until independence, all across the region. This was especially the case in countries governed by Sir Arthur Gordon, who saw himself as the protector of the Fijian people originally by separating colonial legal rule from indigenous customary rule. Sir Arthur Gordon was one of the first governors that came over to manage British protectorates in the region. And you can read stacks about the guy. Go and Google Sir Arthur Gordon. His segregation policies served the existing elite, both within the in the colonies, and the elites within indigenous communities, the chiefs and leaders, and their descendants and those around them, who by and large benefited over the years. That's not to say that they benefited at the expense of their own people. Why would a Fijian leader agree to subject their own people to foreign laws and ideas when they're standing on their vanua? Of course you'd accept segregation. How crazy to not? Well, an unfortunate long-term result of those policies was that they kept indigenous Fijians out of education, except through missions, commercial interests, except on relatively unfair terms, and political power, all of which were rapidly developing in the colonies, right up and until independence. One advantage for Fiji over perhaps other places was how much of their land indigenous owners retained control over. The segregated administrative structures meant that only the elite received education overseas at the time. They returned to see how easily led their uneducated and by now highly religious people were. Some leaders decided to lead their people to independence and a self-determined future, while others have profited. When they led their people to independence, what different independent structures for each country in the region were considered? There were constitutional commissions, and we can study the history of those around the region. There are debates on the record that you can look up in the library. Some efforts were made to develop locally relevant systems, but around the region, the governance systems that we have are more or less a version of the constitutional parliamentary system of Britain. Today, do we think the constitutional parliamentary systems that we have in our country should be completely scrapped? Should we chuck them out, do something else? Or do we think it just needs some reform here and there, some extra resources over here, some more better policy thinking and more technical drafting in this law or that law? Well, are your thoughts about that influenced by the fact that you grew up under this system? Are your thoughts about that influenced by the fact that you're studying law? Post-colonialism is a way of recognizing, looking at our society through this post-colonial lens is a way of recognizing all of the things which are effects, results, touched by, influenced by colonialism. And consequently, it can offer insights into our own patterns and habits of thinking, in addition to insights into the way our societies are. This idea that we can understand some aspect of the world around us using different theoretical approaches or looking at the world through different theoretical lenses is really important. It is the basis for academic study of observable and especially unobservable phenomena. It is also important as a lawyer, where you can only rely on your knowledge and the bits and pieces of evidence you're able to find about your client's case. And you need to make constant assessments of your client's prospects through the twists and turns of the case, a changing strategy. I think the take-home point, which I think we've sort of beaten to death a little over the years, I guess, is that where we are in a post-colonial Pacific world is a place that has been influenced by hundreds of years of ideas cross-pollinating from overseas. Ideas that fundamentally change the way customary societies live and operate, and things that impact where we can go in the future, the choices, the directions, the policy options available based on the social and economic circumstances that we're faced with. I say it's important to understand as deeply as the wisest scholar the history of your own country, and also of the region, so that you actually have ways of measuring or tracking the momentum and trajectory of values, rules and ideas which shape law and law reform today. The crux is this: we can't turn back time. Most of us don't want to. However, we grieve what was lost. Histories, stories, dances. We grieve what has come with it. Pollution, foreign threats, politics, corruption, oppression, segregation. The state exists, and most people seem to prefer their constitutional bundle of rights over those bundle of rights they would otherwise be receiving under custom, especially women in the region and children who, it seems a lot of people in the region, when I go on Facebook, still think it's okay to beat. So if we're not going to go all the way back to the past, we have to go forward from here. And as I've already said, understanding where here specifically is means understanding quite a lot of history. So let's do an example of how we might use a post-colonial lens to look at things in Vanuatu. Why do you think the drafters of the Vanuatu Constitution gave custom a lower status than what was given to colonial laws? Should it not have a higher status to reflect the reality of life for the Vanuatu people? By and large, if you live outside of Port Vila or one of the big towns, state law doesn't spend a lot of time regulating your life. Village life is regulated by custom. Well, we might start by asking, well, in Vanuatu, who was present for the signing of the new constitution? People sitting in cafes, speaking French with the French, English with the English, translating it to Bishlama for the common people? Who were they? By and large, leaders. Leaders with good intentions. We might ask, how has the lower status of custom relative to colonial laws affected justice in Vanuatu since independence? We might ask, how has the lower status of custom relative to colonial laws affected perceptions of legitimacy of state laws and of the formal legal systems in Vanuatu? This slide shows us an example that the drafters of the Vanuatu Constitution anticipated that Parliament might one day make rules for working out what customs are and when they apply and to whom they apply. although they have never done so, not for 30 years. Why? Well, there's lots of reasons. You could tell me lots about custom, couldn't you? One of the possible reasons is the lack of certainty of customary law. That might be one reason it was given a lower place in the hierarchy. Whose custom applies to whom in what place? But that doesn't make custom any less real for a person whose house is burnt down in punishment. Even if a judge wanted to rely on custom in a judgment, they're not trained on how to find and use custom. Where is custom? Where is evidence of custom? Custom is oral. Although places are writing it down, and that has its own challenges. But for a lot of foreign judges, custom's not really law. True law to them emanates only from the state. But this is not a pluralist view. This is a narrow view, and it doesn't reflect the true nature of our post-colonial society. That we are bounded and governed by many legal orders, one of which is an order of customary law. And yet we see this lack of resolution, challenging the realization of justice in society. Well, this is a problem created by colonialism, and is a problem that is ours to solve in the post-colonial era. This slide is interesting. A 2014 constitutional change means the government of Vanuatu must consult the Council of Chiefs in relation to law on areas that affect their interests, such as land, custom, and so on. This change shows us a strong example of decolonisation in Vanuatu. An attempt since independence to decolonise aspects of law, to give more consideration to custom, to unwind some of the constraints and barriers we thought or we accepted previously within our governance system. Although note, this mandatory consultation with the Council of Chiefs does not mean the government must also follow their advice. Maybe that's a good thing, maybe it's not. Well, how does that compare to Fiji, where in 2009 the constitution was abrogated and the Great Council of Chiefs was disbanded? Is that progress or is it not progress? Those who abrogated the constitution and are the current democratically elected government of Fiji say that this was necessary. Others disagree. Here we all are more than a decade later. Has everyone just forgotten about that? Well, no. But if you arrived in Fiji today and you wanted to understand this problem, the issue of custom, the issue of relations, well, you would, if you knew the history of these things, you would tell this ignorant person you've just met that they might want to understand some of the history in order to better understand what you might observe of people's interactions today on Facebook and forums and in the community, and to understand these things that have shaped their view of how the world should be and how the world is. This slide shows us a different part of the paradigm for post-colonialism in Vanuatu. The problem that island courts have not been empowered with their full jurisdiction under Section 52 of the Constitution is a problem that is clearly post-colonial in origin. There were no island courts previously. Well, maybe there were some under the joint French-English colonial system. I'm not too sure. But even if it were, that would be a problem that is colonial in origin. Fixing the problem is not as simple as reissuing the warrants, establishing the courts to expand their jurisdiction. There is a deep lack of financial and human resources, for example, within the law and justice sector to support the existing law and justice system, let alone the surge in demand that would come from an expansion of a court's jurisdiction. And we've already identified the problem of identifying custom. That might be something that the courts develop better precedent and rapidly accelerate jurisprudence on if only they had the jurisdiction. But careful development of jurisprudence also requires training and oversight and support, all of which exist in very modest quantities within the existing system. One thing we might take away from this is that any effective solutions to these sorts of problems will likely need to be incremental and develop over time, focusing on long-term goals. Another thing we might take away from this is that if we're interested in improving things like access to justice and dispute resolution, the fastest and most immediately beneficial solutions are unlikely to come through a law reform process. This slide shows a very interesting example, also from Vanuatu, of the influence of post-colonialism in the area of jurisprudence. Way back in 1996, the current Chief Justice, Lunabek, was a magistrate. He made a decision in a case, Weiwo and Weiwo, which sought to uphold the use of customary law in adoption matters. The case was appealed, and the then expatriate Chief Justice overturned the decision, and the opportunity for a decolonized approach to adoption in Vanuatu was missed. I offer no analysis of the legal decision. Perhaps Justice Lunabek was truly mistaken in his approach. But perhaps as a junior and then younger and less experienced judge, he was not so confident to push on the rightness of his judgment. And perhaps had he done so, the Chief Justice might have been less inclined to overturn his judgment. Be that as it may, being a court of appeal decision in a common law jurisdiction such as Vanuatu, the decision unfortunately set a precedent. And viewing this decision through a critical post-colonial lens, the decision was detrimental to the recognition and application of custom by the ordinary courts of Vanuatu. Its strong Court of Appeal precedent has influenced law ever since, and unfortunately discouraged lawyers from arguing for the inclusion of custom or the consideration of custom in judicial decisions. So, moving along then, there are many different social theories. Post-colonial theory and ideas of decolonization are one of them. Feminist theory, feminist legal theory is another. There are obviously many different types of feminism, and they all have slightly different perspectives. This slide provides a very simple overview of feminism as a social theory sufficient for LW305. Keeping with this idea of lenses, we're interested in taking these perspectives of transforming social relations and seeking to identify the implications of rules and practices on women as a lens for analyzing laws. For example, we might ask, how does a particular law affect women? Are women disadvantaged by the law relative to men? Inequality of pay, inequality between the genders, is a social problem, a deep social problem. Social problems require social solutions, in addition sometimes to legal solutions. But law alone cannot change the hearts and minds of the people. Feminist theory shows, amongst other things, that the law as a whole, legal system, the legislation, case law, state institutions and ministries and so on, and customary law and the systems and institutions that are all, and practices and ceremonies that are all part of that, are in some cases ineffective at achieving whatever their objectives and goals are. Amongst other reasons, because they create inequalities and discrimination towards women, or because they maintain the inequalities that already existed in society between men and women. By doing so, the law not only perpetuates the subordination of women, but also maintains the domination of men. Just as custom creates systemic systems discriminating against women, state laws and state institutions are often powerless or ineffective at correcting it. Feminist theory is very interested in the neutrality of law and to the idea of substantive equality. Real equality, substantive, of substance, real, as opposed to equality that's not real. It just exists on the books, on the letters. The law says this, but in practice, what happens is something else. But the central idea I want you to focus on is the idea of using feminist theory as a lens to study something such as law. The effects of post-colonialism are all around you, and most of you should understand that it's possible to explain why something you observe around you is the way that you observe it because of the complex consequences of colonization and domination and everything that's happened since. Well, a feminist lens is another good example of this idea, of using a different lens, because there are so many laws which discriminate against women still. So it's quite easy to introduce you to this idea of using lenses, using these ideas of post-colonization, colonialism, and feminism, because hopefully these are examples which are very familiar to you. A casual example appears on this slide of analysing a law using a feminist perspective or critique. A rule saying you must be 1.8 meters tall to join the police force. Well, this might be a general rule, and it might be a real rule in some country of giants around here where I live. I've seen some very short police officers, so I don't think such a rule exists today, if it ever did. But let's just say that you have this rule for argument's sake. It appears to be neutral, doesn't it? 1.8 meters tall. It's just a number. It's just a minimum standard, a minimum requirement. It applies equally to everyone under 1.8 meters tall. But of course, women are generally shorter than men. So there's indirect discrimination in the law, quite extensive. Very few women are towering above 1.8 meters tall. On the one hand, you might say, well, there's no problem to fix. Police need to be big and strong to deal with criminals. On the other hand, that position can be challenged. For example, Fiji rugby legend Jerry Tuwai is only 1.7 meters tall. I think he's maybe even a little bit shorter. I think they're being generous. Is he too small and weak to be a police officer? What about the Fijian female weightlifting champion, Eileen Thikamatana from Levuka? At 19 years old, she won the gold medal at the 2018 Commonwealth Games. She's only 1.7 meters tall, but she broke Olympic records weightlifting. Stronger than most men. Her weight, size, probably stronger than Jerry Tuwai. He's not powerlifting. So that argument that, there's no problem to fix, police need to be big and strong. Well, women can be big and strong, and men can be short and strong, or short and weak. Then there's the other point that, what does muscles have to do with investigating crimes? Do you need a muscle to talk to people? Do you need persuasion and influence? Do you need good social skills to investigate crimes and get people to admit things that they were trying to hide? Maybe these are skills that different people in society, a broad spectrum of society, has more of than big burly men. If we approach this problem using the lens of Powell's minimum standards framework, which we're going to consider in depth next week because it's relevant to your assessment in this class. But, hint, Powell's minimum standards framework is another theoretical lens we're going to ask you to apply. Well, our first question might be to ask, is the rule appropriate, this 1.8 meter rule? Is it appropriate that there's discrimination? Is it fair? Sometimes it is. Well, according to Powell's minimum standards, the law should also be responsive. Is an all-male police force the best equipped to respond to the many different needs of the community? I've already suggested I don't think it is. What about the fact that police also need to represent the community, ethnically and by gender? What if all the police in Fiji were white? What if all the police in Samoa were Tongan? What if all of the police in the Solomon Islands only spoke Russian? Do you think the police would be better or worse at protecting the community and investigating crime? So if we think that 100% or even a 50% Russian-speaking Solomon Islands police force might find it a little bit harder to police, then why wouldn't that also be true of a gender unequal police force? There is a law in Vanuatu which permits customary reparations to be considered by courts when rendering their judgment in cases, including sexual offences such as rape. On its face, this law appears neutral. Again, it applies equally to men and to women. The law is trying to do a good thing by seeking to recognise customary law approaches to ensuring peace and social harmony in the community. This seems to be decolonising. This seems to be a good thing. Good intentions. However, if we go and collect data on cases, what we see is that over 90% plus of survivors of rape in the community are women or children, and the perpetrators are nearly all male. Through a feminist lens, we might argue this law does not produce substantive equality. Despite any good intentions it may have, it doesn't actually result in fairness, because men are protected relative to the female victims in the interests of peace and harmony within the community. I'm not saying that's good. I'm not saying that's bad. CEDAW has a strong focus on substantive equality, real equality. And as lawyers, you're walking a pretty tight line of also supporting the idea of equality before the law and equal rights. But for some places, maybe the right decision sometimes is a decision in the interests of peace and harmony in the community. But when we're talking about violent sexual crimes, it starts to become a little bit more awkward to defend reduced sentences for rapists and child abusers. It is a complex issue with no easy solutions. Law reform might be part of the solution, but again, alone, the law can be a very poor agent for social change, whatever change that is that we want. There are many different ways of interpreting Pacific history. There are different lenses we can use to examine the problems we observe around us today. Different lenses may offer insights into different ways of understanding the problems around us. They may also offer insights into different ways of solving those problems, or at least coming up with solutions to try and test. Of course, some lenses may offer very little insight at all, and it helps to know which ones are going to waste your time by trying to understand and apply. Other lenses may seem to explain everything we need to know. I will leave you with this. The systems that we have now, there are things about them that are unjust. There are things about them that really don't fit our ideas about the kind of society we want to live in. Change in any complex system is inevitable. As we have seen, change in our social and political orders over the last 100+ years. Deliberate, intentional change in a direction that we want the change to go in requires focus and effort. The ultimate question for you now is, what do you do about that now that you know? What are the ways forward?